Yeah. Welcome everyone to our 32nd annual meeting of the Armenian Bar Association. This is the first time we're having a hybrid meeting, so we've got people who are joining us on Zoom and okay, speak louder. This is the first time we've got people joining us, and so we're just gonna manage through our technical difficulties as we get started. Last night we had a beautiful reception, and when we were anticipating we would just have about 15 or 20 people attend in person, we had well over 100, and that was louder. Okay, and that was really surprising, but I think it was a testament to our desire to come together and our desire to you know what? Is this better now? Oh, no, we actually disconnected completely. Okay. Okay, can you all hear me now? Okay, so I think it was a testament to our desire to come together and just see each other. We met some new friends, some friends we hadn't seen in a really long time. We've turned things around a little bit. We're going to have our panel discussions first. After the panel discussions, we'll go into our business meeting of the bar and then the board meeting. So we welcome you to stay for the entire program. I'm going to recognize one of our dear friends that we've been working with from the permanent mission, Sofia Margarian. Thank you so much for being here in person. If you get a chance during a break, please by all means say hello to her. She's here with the permanent mission. She has also brought with her someone who probably should be a member of the Armenian Bar Association, Levon Golendukhin, who was the head of the legal department at the Ministry of Foreign Affairs, and now he's here at the mission directly. And I also want to thank and recognize just very quickly some of our former chairs who are here, with Harry Churkin from Philadelphia, sitting right next to Harry Dikranyan from Montreal, Armen Hovhannisyan, Gerard Kasabian from California, Sonia Narcessian from Boston, and Gary Mumjan actually from New York, a local. We're going to go right into the program. This program started as a result of a legal initiative that we took on right after the Artsakh war. We started to evaluate the various things, the legal matters that we could take up. And born out of that discussion was a subgroup that we established under the leadership of Levon Golendukhin here and Grant Hanesyan. And that group has been looking at various issues relating to the legal recourse Artsakh can have. We've had a number of programs throughout the year that relate to that. This one in particular, we're very proud of because two of our youngest members actually took on the initiative to work on something that I think you all will enjoy hearing about, having to do with the UN. Levon is our moderator. I'm going to pass the mic on to him and allow him to be the person who does the introductions of our presenters.
Good morning, everyone, and welcome to New York. First off, thank you to Hughes, Hubbard, and Reed for sponsoring this first and second CLE program, and Konstantin Cannon for graciously hosting us in person with the incredible views of Grand Central Station behind us. My name is Levon Golendukhin, and today with me, I have two distinguished panelists. Sitting to my right is Alexander Bedrosyan, who is a litigation associate in Washington, D.C.'s Office of Hughes, Hubbard, and Reed, and is a member of the firm's International Arbitration Practice Group. His practice focuses on public international law, investment treaty arbitration, and international commercial arbitration. He has particular experience assisting in disputes involving former Soviet republics and has experience in the real estate, mining, banking, aviation, construction, and retail petroleum industries.
The mic is
This year, Alex was recognized by the Legal 500 in the United States in the field of international arbitration. Second, but no less impactful, attending with us virtually is Astghik Hairapetian, who is a law clerk to a federal district judge and serves as the legal advisor to the Rerouted Archive. She has interned at the Center for Justice and International Law, focusing on the Inter-American human rights system, as well as at the UN International Residual Mechanism for Criminal Tribunals in Arusha. In law school, Astghik acted as the chief comments editor of the UCLA Journal of International Law and Foreign Affairs. Her publications appear in the UCLA Law Review, the Berkeley Journal of Criminal Law, and the Loyola of Los Angeles International and Comparative Law Review. While their impressive profiles speak for themselves, an additional circumstance brought us all together. Over the past several months, Alex and Astghik have led a team that has prepared and submitted a complaint to the UN Committee on the Elimination of All Forms of Racial Discrimination on behalf of a victim of forcible displacement in Artsakh during the conflict last year. I'm sure you're as excited as I am to hear from our distinguished panelists about this unique mechanism for recourse to violations of human rights. Their presentations today will walk us through, first, an introduction of public international law. Then, they will discuss the sources and operation of international human rights law specifically. And finally, they will examine how human rights are enforced before the UN treaty bodies and a few other human rights institutions under international law. I have saved a few minutes at the end to take questions from the audience and the chat room, and I ask that you kindly reserve your questions for that time. With that, I hand the microphone to Alex.
Thank you very much, Levon. I hope I speak at sufficient volume. It's great to meet you in person finally. And Astghik, very nice to see you again. Hello, everyone. Thank you so much for coming. For about 12 minutes, I'm going to give a crash course in public international law, taking some detours that are particularly relevant to us Armenians and also for the human rights initiatives that we've done. So public international law is the rights and obligations established by sovereign states. In this context, states means not Texas or North Carolina, but countries of the world. And what does it mean to say that a state is sovereign? Well, this means that no other state or entity can tell a state what to do. There's no one above states in the international system. No world police. Unless, okay. All right, so no other entity or state can tell a state what to do, unless states assume obligations voluntarily. This is the key characteristic of the international law system. A state is bound only by those obligations that it undertakes voluntarily. But once it undertakes it, it is still bound by it. So sometimes colloquially we hear, oh, why doesn't Armenia take Turkey before such and such court? Well, because Turkey hasn't assumed an obligation to accept the jurisdiction of that court. States assume obligations by signing on to treaties or through what's called custom. Custom is a long-standing practice by most states of the world that arises out of a belief by the states that it's a legal obligation. So one example is piracy. With thankfully few exceptions, we don't see pirates ransacking different countries and ports. This is because for hundreds of years, states have refrained from engaging in piracy and have punished piracy out of a belief that piracy is illegal. So it's one example of custom. Another key aspect of the international law system is what I've called here the subjects, the original subjects of international law are opaque states. Subjects of international law means which things are granted rights and obligations under international law. And at least 70, 80 years ago, definitely up until the 60s, the only actors in the international law system were states, and they were opaque states. This is why the billiard balls here are not transparent, because international law didn't recognize the things inside of states. They were like people, corporations, NGOs, nothing. It was all just states. And here's one example of this. The ICJ statute. ICJ is the International Court of Justice. It was established in 1945 by the same time as the UN was established. It was available only to states. Individuals couldn't bring claims or anything like that. And to illustrate the consequences of this, let's pretend that this discussion was taking place 80 years ago when the UN was founded, 1945. Then let's assume that Levon went to China and got into a fight with some hooligans, and the Chinese police roughed him up, detained him, committed wrongs against him. Technically speaking, under international law, the way it was conceived then, no injury would have been done to Levon. The injury would have been done to Levon's country of origin, which I'll admit for the people is Canada. So if any entity wanted to vindicate the international law rights here, it would be Canada. But Canada might not want to do anything. It might think, oh, we have all these other priorities with China, and if we make a big fight because of this guy Levon, it's going to get in the way of those other priorities. So all that is to say, this is an example of how the original conception of international law was very disempowering to individuals. Individuals could not protect themselves or vindicate their own rights until international law evolved to recognize other subjects like humans, which I'll get to. But before I get to that, I want to pause for a moment on something that we've all probably heard. Well, let me ask, territorial integrity. Has anyone here heard this in connection with the war said by Ilham Aliyev or others? Well, territorial integrity also arose during this original period of international law when it was all about states. It's here in the UN Charter, 1945, which says all members shall refrain in their international relations from the threat or use of force against the territorial integrity of any other state. Now, this idea, this fact that territorial integrity arose at a time when international law was only about states, it's relevant when a group of people, it's relevant to assessing the legality of whether a group of people within a state can secede. Kosovo, we all know that Kosovo declared its independence, and the International Court of Justice issued an advisory opinion on the legality of this. I think it was in 2010, and it analyzed the impact of territorial integrity, the relevance of it. And it said, thus, the scope of the principle of territorial integrity is confined to the sphere of relations between states. So it's when one state takes territory from another state, not necessarily when a group within a state declares independence, which I'll show here visually in a moment. But I just want to say, the ICJ's position was exactly the same argument expressed by the United States before the court. It said territorial integrity, the principle of territorial integrity does not preclude non-state actors from declaring independence. So basically, this is what we're talking about when we're talking about territorial integrity. One state taking territory from another state. But this is what happens in a situation like Karabakh or Kosovo or others. People within the state declare independence. It does not implicate the norm of territorial integrity. And the reason why the ball here is, it turned from black to gray is a clumsy way of showing that you need to kind of pierce the veil of the state and recognize actors within the state in order to look at the Declaration of Independence. And as international law was originally constituted, you didn't do that. It was just opaque billiard balls. So what does international law have to say about when people secede from a state? Well, if it is a disguised breach of territorial integrity, as in a disguised use of force by one state against the territorial integrity of another state, it's prohibited by the territorial integrity norm. I would say Cyprus is an example of this, and Crimea. I should say here, it doesn't matter if it's not necessarily one state taking the territory and annexing it to itself. It could just be also, it just takes it away from the other state, like Turkey and Cyprus. Something of relevance to us, in the past couple decades, arguably, this is controversial, this idea of remedial secession has arose, whereby if secession is the only way for a people to safeguard fundamental human rights, including the right not to be slaughtered, international law arguably affirmatively permits the secession. It creates a right to secession. But aside from these two narrow circumstances, anything else, international law is silent. It doesn't regulate, doesn't allow it, doesn't prohibit it. So in those cases, what do? You can look to the domestic law of the parent state. And did that allow the secession? And in the case of Karabakh, we'd be talking about the Soviet law, the law on the Soviet Union in 1990 on secession of union republics and of autonomous oblasts within the republics. Or you go to power politics, which is basically, you know, life is unfair. If the people manage to assert control over their territory, push out the army of the main parent state, and if they can get other states to recognize them, then congratulations, they have a state. So most cases of secession I would say they fall into this third bullet of international law doesn't go one way or the other. Anyway, after that detour, we're back to the evolution of international law. It began, thankfully, to recognize other subjects, including individuals. Individuals as rights holders, as human rights treaties began. And these are revolutionary because not only did they recognize that these individuals have substantive rights, like the right not to be killed, etc., they also gave them the right to directly sue the state that abuses them. So in the Levon example, he would no longer have to go through Canada. He could sue China directly if he wanted to. Individuals also became holders of obligations under international criminal law, and transnational corporations were recognized as being rights holders, such as in international investment treaties, which is how Levon and I make our living primarily. And just very briefly, I want to talk about enforcement. There are three types of international law that have a direct international enforcement mechanism. International investment treaties, there's a whole system for if a state owes you money, the investor can go and find state assets and take them, satisfaction of the debt. International criminal law, if someone commits a crime like genocide or crime against humanity, that person can be arrested by other states and sent to The Hague. There's a whole system for doing this. And UN Security Council resolutions, those that are brought under Chapter 7 of the UN Charter. This is the chapter that says if there is a breach of the peace, the UN Security Council orders the state to stop. And if it doesn't stop, the Security Council resolution can authorize the use of force by other states to enforce the resolution. Very important. The 4 Karabakh resolutions from 1990 were not brought under Chapter 7. They did not authorize the use of force. They did the opposite. They called for a ceasefire. So to the extent anyone is arguing that, Azerbaijan had a right to start a war to implement the UN Security Council resolutions, I would strongly disagree with this. And one final note, you might ask, why would a state bother to pursue something under international law other than these three branches where there's no enforcement mechanism? Well, unfortunately, we saw a great example in the Karabakh conflict of how even non-enforceable international law could be very useful in advancing a state's political argument. If any of us have had the misfortune of following Azerbaijan's public speeches over the past 30 years, we might know that every fifth word out of the mouth of the Azerbaijani foreign minister or president has been to cite these 4 UN Security Council resolutions. Not enforceable, but nevertheless useful. And then in my experience, when the war happened last year, what did all the media put in the second paragraph? They mentioned these UN Security Council resolutions. So it's a good example of how even non-enforceable international law can be very useful in advancing a state's political argument. And with that, I'll pass it over to Astghik to talk about international human rights law.
Thank you, Alex. Thank you, Levon, and everyone that's here, whether remotely or in person. I hope, is my volume okay? Okay. So that was the first section regarding public international law. And thank you again, Alex, for that really great summary. For this next section, I'm going to provide an overview of the international human rights law system as a whole, including the instruments and the monitoring bodies that are involved. So the cornerstone of the international human rights system is the Universal Declaration of Human Rights from 1948. This is non-binding, but it does set forth what we understand today to be human rights. And many parts of it are today considered customary international law, which means that even if this document itself is not binding, states are still bound by certain obligations. After the Universal Declaration of Human Rights, we got 2 important covenants on human rights. The first is the International Covenant on Civil and Political Rights, or the ICCPR, and the International Covenant on Economic, Social, and Cultural Rights, or ICESCR. So these 2 are treaties, which means that states which are parties to them are bound by these obligations. Something else to keep in mind is that the split between civil and political rights on one hand and economic, social, and cultural rights on the other hand, that persists to this day, and we'll see the split in later human rights treaties. For a number of reasons, civil and political rights have taken precedence, but that is slowly changing. So to illustrate the difference between these types of rights under human rights law, the ICCPR, for example, protects the right to life, the right to be free from torture, the right to liberty, freedom of thought and religion, whereas ICESCR protects the right to work, the right to an adequate standard of living, the right to health, the right to education. So you see the differences in the types of rights that it protects. So one question you might have, Alex mentioned international criminal law earlier. So does international human rights law, and specifically the right to life, for example, mean that all killing during war is illegal? Unfortunately, that's not the case. When there is an armed conflict, a special set of rules apply, and that set of rules is called international humanitarian law. Briefly, international humanitarian law has 2 important principles. The first is distinction, which means that warring parties have to distinguish between civilians and military objectives. The second is proportionality, which means that even when a warring party is striking a military target, it must ensure that the damage to civilians does not outweigh the military advantage that they expect. The relationship between international humanitarian law and international human rights law is a bit unclear, but there is a general agreement that international human rights law continues to apply, at least to some degree, even during armed conflict. I'm going to start by speaking about the universal human rights system, and this is in contrast to the regional human rights systems, which we will discuss also afterwards. The universal system is composed of the International Bill of Rights, which we just discussed, the Human Rights Council, and the other human rights treaties. We'll start with the Human Rights Council. So the Human Rights Council is not a treaty body. It was based on the authority of the UN Charter, and it's composed of member states, representatives of UN member states, and not independent experts. And it has 3 primary functions. The first is overseeing what's called special procedures. Special procedures is kind of a broad umbrella for a number of things. It includes special rapporteurs with country mandates or thematic mandates or working groups on specific issues in human rights. Each of the special procedures can receive individual communications regarding alleged violations, but this is not in any way a judicial process, so it's not like the complaints procedures, which we will discuss later. A second function of the special procedures is to put out reports on individual issues within their purview, and they sometimes put out calls for input from civil society on these specific issues and eventually incorporate that information into their reports. So to give an example of this, the Special Rapporteur on Contemporary Forms of Racism put out a call for input in advance of her upcoming report on the glorification of Nazism and related practices. And in response, the Armenian Bar Association submitted a report on the Grey Wolves. So that was the special procedures. That's one function of the Human Rights Council. The next function is its own complaints procedure, which is unique compared to the treaty body's complaints procedure because the Human Rights Council is not a treaty body. That means that an individual alleging a violation can file a petition regardless of whether that country has signed a particular treaty. It's different also in that it's a confidential process and it's focused more on state cooperation rather than putting out public decisions, unlike the treaty bodies. And the third function of the Human Rights Council is overseeing the Universal Periodic Review. And that's when each country every 4 to 5 years has its human rights record reviewed by 3 other states. Those 3 states are called the Troika. And the Troika reviews a number of sources to determine how that state is doing in terms of its human rights obligations. It'll consider that state's own reports, which, as you can imagine, are probably going to be pretty biased. So it will also consider other reports to supplement it, including reports from the treaty bodies regarding that state, as well as what are called shadow reports, which are reports from civil society, which supplement this process. And as an example of a shadow report, the Rerouted Archive, which collects testimonies of Syrian Armenians, submitted a shadow report for the upcoming UPR on Syria regarding the rights of Syrian Armenians. So that's the Human Rights Council. And now, before you start wondering if we'll ever get there, considering the title of this panel, we're going to talk about the treaties. We're going to start and talk a lot about the Convention on the Elimination of All Forms of Racial Discrimination throughout the presentation, but just bear in mind that a lot of the treaties have very similar structures as far as its functions. So what we talk about here will be relevant across the board. Some of the rights that this convention, which I'll call third, protects. Under Article 2, states must not engage in or support racial discrimination. Article 4 prohibits racist propaganda, and we'll talk more about Article 4 later on. Article 5 prohibits racial discrimination in guaranteeing some of the rights that we talked about in the ICCPR and ICESCR. So civil and political rights, which is the right to life, and economic, social, and cultural rights, such as the right to housing. And we'll talk more about this as well later on. Article 7, states must adopt education policies which combat racial discrimination. And finally, I'll mention that CERD is unique amongst the 9 human rights treaties in that it does have a state-to-state complaint procedure, which means that instead of just an individual alleging that the state violated my right to X under this treaty, a state can actually allege that another state has violated its obligations under the treaty. And that is unique, as I said, amongst the treaties. So the body tasked with monitoring compliance with the treaty, a treaty body, it's called the Committee on the Elimination of All Forms of Racial Discrimination, which I'll call the CERD committee. And it has a number of functions, and you might see some parallels with the Human Rights Council as far as the functions of this treaty body. The first is it requires states to submit periodic reports on their compliance with the treaty. And then the CERD committee will issue what's called concluding observations, what it thinks of the state's compliance with its obligations. And similar to the Universal Periodic Review, the CERD committee will also look at shadow reports from civil society regarding that particular state's compliance. So as an example, in December of last year, the Armenian Bar Association submitted this alternative report, the shadow report for Azerbaijan's review under the CERD committee. The other functions are to adjudicate the individual complaints that it might receive, which we will talk about more in depth later on. The state-to-state communications, which I mentioned, which are unique. And finally, it will issue general recommendations, which help interpret certain aspects of a treaty. So briefly, the other treaties, we talked about the ACCPR It also has a treaty body, it's the Human Rights Committee, very similar functions to the CERD committee. Same with ICESCR, the Committee on Economic, Social, and Cultural Rights. Again, very similar functions. And just for your information, the other human rights treaties, there are 9 in total, are the ones up here. And again, they all have very similar structures to the ones that we've been discussing. So that concludes the discussion on the universal human rights system. And so the next section, we're going to discuss the regional human rights systems. There are 3 of them. There's the European Court of Human Rights, the Inter-American Human Rights System, and the African Human Rights System. And for the European Court of Human Rights, I'm going to hand it off to Alex to help us understand the importance of that.
Thank you very much, Astghik. Great. So the European Court of Human Rights, it might be the most familiar to us, which I'll explain in a moment, but it guarantees both civil and political rights, as well as property rights. And I would characterize its approach as a little bit deferential to states. The term it uses is the margin, states have a margin of appreciation in dealing with people. This is somewhat comparable to the tiers of scrutiny in US constitutional law for US lawyers here. Basically what this means is, so yes, the European Convention on Human Rights, it protects all, like right to privacy, right to life, things like that. But it's not the case that anytime a state interferes with those rights, it's a violation. The interference is okay if it meets a few characteristics. If it's stated in the state's domestic law, that sometimes the state will interfere with your privacy in certain cases. If the restriction is in pursuit of a legitimate aim, like national security. And the biggest one is there a sufficiently close connection between the restriction and this aim? The words in the treaty to say this are, is it necessary in a democratic society, or is there a fair balance between the public needs and private rights? That's used in the property rights cases. And fans of the late Justice Scalia will wince at this, but the European Court of Human Rights has said that it's a living instrument which must be interpreted in light of present day conditions. This 1978 case was about corporal punishment in schools. Apparently, until then in England, the teachers would take birch bark and hit a misbehaving student. And the European Court found that this was violated the prohibition against degrading treatment in light of the present day conditions already in 1978. Armenia and Azerbaijan at the European Court of Human Rights both became parties in 2001. When they both became parties, they each had to promise to resolve the Karabakh conflict peacefully, only peacefully. There is Armenia's commitment. It said, as you can read on the screen, Azerbaijan made a similar commitment, a letter from the President Heydar Aliyev, stating that Azerbaijan commits to continue efforts to settle the conflict by peaceful means only, and to settle international and domestic disputes by peaceful means. There are a couple of cases about the Karabakh conflict that are quite interesting. Shiragov versus Armenia. Mr. Shiragov was an ethnic Azerbaijani citizen from Lachin who was displaced during the First War. And he brought a claim alleging that Armenia was violating his right to property because his house from which he was displaced was in Lachin. The key question here was, does Armenia owe European Convention obligations within territories of Karabakh and the surrounding regions? Article 1 says that a state's obligations apply to everyone within their jurisdiction, and jurisdiction has been interpreted to mean territory, not just that belongs to you, that you claim belongs to you, but territory that you control, effective control. So the question is, did Armenia have effective control over Lachin and Karabakh? Armenia's position, as we know, is that this is not it as a state was not occupying certain neighboring land. It was Karabakh itself that was acting on its own. Azerbaijan's position was no, the Nagorno-Karabakh Republic is a puppet of Armenia, and it's Armenia doing it. Well, the European court sided with Azerbaijan, or rather the Azerbaijani applicants in this case, finding that basically Armenia controls Nagorno-Karabakh Republic, so Armenia's European Convention obligations do apply in Lachin and Karabakh. And immediately Azerbaijan began promoting this decision in various fora. So it's another example of how technically non-enforceable, binding but non-enforceable international law decisions can really go a long way in advancing a state's political argument. Here that it was Armenia that was doing an occupation. Now, there was one important case against Azerbaijan brought May of last year. This related to the Ramil Safarov affair. As you may know, Ramil Safarov beheaded with an axe an Armenian soldier who was sleeping. And he was convicted of a premeditated murder and a hate crime in Hungary. But as soon as he was extradited to Azerbaijan, the president of Azerbaijan pardoned him and made him into a national hero. The relatives of the victim claimed that this pardoning violated the right to life because it gave impunity for murder. And part of a state's right to life obligations is to punish murders that happened. But it also made another claim that this was also a violation of Article 14, which is the non-discrimination obligation. And the argument was that the pardoning of Safarov was racially motivated. It was because Safarov's victims were ethnically Armenian. And the court fully agreed with the Armenian applicants, saying that the actions taken by the Azerbaijani authorities in respect of Ramil Safarov were racially motivated, and that they had a causal link to the Armenian ethnicity of his victims. So this is an authoritative finding by the European Court of Human Rights that Azerbaijan, in this case, acted with malice and in a discriminatory manner towards ethnic Armenians because of their ethnicity. And I submit that had there been more such decisions over the past 25 years and had they been more widely promoted, the narrative during the war last year would have been very different. So now I'll pass it back to Astghik to talk about the remaining two regional human rights systems.
Thank you so much, Alex. So as Alex mentioned, I'm going to talk about the remaining two, the Inter-American system and the African human rights system. So the Inter-American Human Rights System has two instruments. The first is the American Declaration of the Rights and Duties of Man and the American Convention on Human Rights. Virtually all the states in the Americas have signed the American Declaration of the Rights and Duties of Man, but not all are parties to the convention. Notably, the US and Canada are not parties to the American Convention on Human Rights. The two bodies that monitor compliance with these documents are the Inter-American Commission on Human Rights, which is based in DC, and the Inter-American Court of Human Rights, which is based in Costa Rica. The Inter-American Commission can adjudicate alleged violations of either the declaration or the convention, but only alleged violations of the convention can then be litigated before the court. The Organization of American States is the larger body within which the Inter-American Human Rights System exists. And this is a statement of the Secretary General of the Organization of American States regarding Azerbaijan's aggression in Karabakh last year. And briefly, the African Human Rights System has one instrument, is the African Charter on Human and People's Rights. And similar to the Inter-American system, it also has a commission, the African Commission on Human and People's Rights, which is based in the Gambia, and the African Court on Human and People's Rights, which is in Tanzania. So that concludes our discussion of the regional human rights systems. And so now we can move on to talking about the individual complaints procedures within the UN treaty bodies, which we alluded to earlier, and this is the function under which Alex and I and the team submitted the complaint, which Levon mentioned at the beginning. So to start, I'll hand it off to Alex to discuss some preliminary considerations.
Thank you, Astghik. I'll be very brief. If someone wants to complain before a international tribunal for violation of human rights, they have to establish the jurisdiction of the state. This is basically, there must be some relationship between the individual and the state. In American tort law, in negligence law, it's analogous to the duty to whom type thing. We talked about this earlier. States have jurisdiction over individuals who live on their sovereign territory and on territory that they effectively control, or if their soldiers apprehend someone abroad. And also people who are affected by a state's conduct in a direct and reasonably foreseeable manner. So the paradigmatic example here would be if a state shoots a bullet across the border and kills someone. It can't argue that, oh, the victim was not on my territory, not on territory I control, so I don't know obligations to him. And interesting, timely, given what's happening in Scotland, Greta Thunberg and others brought a claim before the Committee on the Rights of the Child, saying that countries that emit a lot of greenhouse gas emissions violate their rights under the Convention on the Rights of the Child. The committee found that these individuals, even though they were scattered across the world, they were within the jurisdiction of the emitting states because it was foreseeable that the emissions would have an impact on these children. Somewhat controversial. But the other big requirement is before a person can run to an international tribunal, they have to exhaust domestic remedies in that state. The idea is here to give a state the chance to solve the problem internally before being hailed before an international tribunal. There are, of course, exceptions to this if there are no real remedies in the state, or if they would take 20 years or something like that, futility, others. And the Committee on the Rights of that Child in that Greta Thunberg case kind of saved face by rejecting, even though it made the very controversial decision on jurisdiction, it then saved face by saying, no, the children have to go to the courts within the countries and try to get them to reduce their emissions that way before going to an international tribunal. And there are other admissibility criteria that are fairly standard, but then I'll turn it over back to Astghik to finish with a detailed discussion about the substance of these rights.
Thank you, Alex. So I'm going to talk now a bit about the merits of the violations that an individual can allege. And there are three primary sources of law for understanding the scope of the rights within any given treaty, any given human rights treaty, I should say. They are past decisions on individual complaints, general comments, and these are also called general recommendations. It depends on the treaty body, but they're functionally the same. And finally, concluding observations on state reports, which we discussed earlier. So I'm going to set up two case studies to help us understand how this jurisprudence works together. The first one is regarding the right to housing without racial discrimination. To start, we would go to the third article, which protects this right. In this case, it's the Article 5E3, which guarantees the right to housing without racial discrimination. The article itself doesn't tell us that much, and that's why we're going to look at some other sources to help us understand what this actually protects. The second case study that I'll set up is on the elimination of racist hate speech. So we'll start with Article 4, which prohibits racist propaganda, including from public officials. You'll notice that the text of the article doesn't actually use the term hate speech, and that meaning is developed through the jurisprudence. So we're going to look at a past decision on an individual complaint. That's that first source of law for the merits of a complaint. The summary of this case is that the petitioners alleged racial discrimination in housing because the city council had approved low-cost housing for Roma people. Then non-Roma citizens started a petition rejecting the resolution, and on the basis of that petition, the city council canceled the earlier resolution. And so the petitioners alleged that this was racial discrimination in housing. So in that decision, the third committee stated that it had to first determine whether there was an act of racial discrimination, and it clarified that racial discrimination can be direct or indirect. So this helps flesh out what an individual has to show in their submission. It ultimately concluded that this was an act of racial discrimination and that the state violated Article 5E3 because it did not meet its obligation to progressively realize the right to adequate housing without racial discrimination. So that was a past decision. I'll note that there are very few decisions on any given article, and there are many articles and many treaties that have never been litigated before the treaty body, and so past decisions are not a complete source of law. So that's why we have to look at some other documents as well. And so we'll look next at general comments or general recommendations. Starting with the Third Committee's general recommendation number 20 on Article 5, which, if you'll remember, is the article which protects civil and political rights and economic, social, and cultural rights, including the right to housing. So this general recommendation says that third, the treaty itself does not create these rights, rather those rights, the economic, social, and cultural rights, are elaborated in other covenants. And so that tells us that we can look at the jurisprudence of other treaty bodies to help us understand the right to housing in the context of CERD. So we can go to the Committee on Economic, Social, and Cultural Rights, general comment number 7, which gives us a definition of forced eviction. And it also states that forced eviction can occur during armed conflicts. So that's very helpful for us to know, given the sometimes ambiguous relationship between international human rights law and international humanitarian law. So going now to our case study number 2 regarding racist hate speech, we can look at general recommendation number 35 of the Third Committee, which says it's particularly concerned by racist hate speech from public officials. And it further recommends that states implement disciplinary measures against officials who do make such statements and provide remedies for victims. So that talks about potential remedies and further obligations once the violation has occurred, which is something that we don't get from the treaty itself. Those are some general comments, and now we're going to go to that last type of jurisprudence, which is concluding observations on state reports. And sticking with our second case study, we can look at the Third Committee's concluding observations on Azerbaijan from 2016, which is the most recent report of the type. And in this one, the committee expresses concern at the inflammatory language used by politicians regarding the Karabakh conflict and discusses this in relation to Article 4 of CERD. And in this same report, they mention the case of Bedrosyan, which Alex just talked about before the European Court of Human Rights. And it discusses the state's pardon in relation to Article 4 of CERD, which has a meaning that it would not have been clear from the treaty itself. So that's why it's important to look at some of these other documents and understanding the scope of the rights that the treaty protects. So that's the merit section. As far as enforcement, I'll just briefly say that if the treaty body does find a violation, it will make a recommendation. It'll invite the state to provide a timeline for complying with the recommendations. It will implement monitoring procedures and follow-up procedures, which is all a public process. And the case remains open until satisfactory measures are taken. And domestic law can also require the state to comply with committee decisions. And that concludes our presentation. Thank you again for everyone who's here in person and remotely. It was an honor, I think, for all of us to be here with you. And please submit any questions, whether in person or through the Q&A function. We'd be happy to discuss them.
Before we transition to Q&A, I just wanted to take a moment for those of us attending virtually to take down the code to get CLE credit. The code is 01353. I believe that's necessary for New York. Just once again, 01353. It's only necessary if you're attending virtually. I think we have a few questions coming in through Q&A. One question is asking to explore sort of the possible ways to pursue recourse for human rights violations. And in particular, we heard just now about individual complaints, but are collective claims, whether multiple individuals or classes, or are those possible, and are interstate claims possible as well? And how do those differ from each other. Astghik, do you want to take that?
Sure, I'd be happy to. So any of the complaints procedures that we talked about, whether before the treaty bodies or before the Human Rights Council, or even to a special rapporteur, all of those can be group complaints. It can be an individual, it could be a group of people, it could even be an NGO. So definitely group actions are possible. State-to-state complaints, as I mentioned, CERD is unique from the 9 human rights treaties in that it does have a state-to-state procedure. And so a state can bring a complaint before the CERD committee. But there's also the option under CERD for a state to bring the case before the International Court of Justice. I don't know if Alex, you wanted to talk more about that option.
Sure, and there's been only one known instance of a country bringing a claim against another country before the CERD committee. It was Qatar brought it against the other United Arab Emirates, Bahrain, Saudi Arabia, when those countries put this big blockade on Qatar. And this is interesting because it brought that claim both before the CERD committee and before the ICJ. But the ICJ took a much stricter interpretation of the treaty than the CERD committee did. The ICJ threw out the claim because it said that the blockade measures by the other Gulf countries were against people who had Qatari citizenship, whereas the CERD in its interpretation protects, when it uses the term national origin, that means like ethnic origin, not citizenship. The CERD committee said it allowed the claim because it said the CERD protects both direct and indirect discrimination. So discriminating against people who hold Qatari citizenship could be an indirect way of discriminating against people who are of Qatari ethnic origin. But then the parties settled the case when I think politically, I think that they removed the blockades once Biden came into office. So was there something else in that question?
Well, I think they were also asking about pending or potential matters to be pursued. I think we want to refrain from commenting on pending cases. I mean, we can know, that we're active in, but we do know that there is a pending CERD case being brought before the ICJ, one by Armenia against Azerbaijan, and then a counter case by Azerbaijan against same case against Armenia. Well, yeah. In each case, we had a hearing recently on requests for provisional measures. But the European Court of Human Rights, many individuals who are detained, held prisoner or hostage are bringing cases too. Yeah. So there are many different avenues. While not commenting on a pending case, I think a couple of the European court cases recently came to an end. Do you, Astghik or Alex, do either of you want to comment on the decisions that came out a few days ago? Astghik?
I think Alex, if you want to talk about those, or Levon.
I'll give it a shot. This was not relating out of the recent war. It was out of the war, the first war, people who were taken prisoner and I think tortured and even in some cases killed. And it took a long time for the case to make its way through the European Court of Human Rights system. And yeah, the court found that Azerbaijan violated the right to life of these people. Interestingly, it did not take the extra step that we saw in the Ramil Safarov case of saying that this violation was also ethnically motivated, even though the applicants asked for it. So it was a real triumph by the lawyers in that Safarov case to get that additional finding of racial discrimination. Yeah.
I have a question in the audience.
So the outstanding presentations are over. I'm curious, can you think of any example of situation in which we'll use Artsakh as a specific example. A people turn to an international body for the determination of their independence or sovereignty. Or two states have a border dispute, and a state presents it to an international body. The two sides subject themselves to the jurisdiction of that body and ultimately accept the result of that international body. Even in the case of Kosovo, 97 countries, I believe, recognize the Republic of Kosovo. Serbia still says it's an autonomous region of Serbia. So has there ever been an example, as in the case of the United States, where you go to the court, there's a fair fight, you take it as far as you can, one side wins, one side loses, and accepts the result?
So for those of us attending virtually, the question was, can you think of an example, or are you aware of an example of an international institution being submitted a dispute either about a seceding territory or a territorial dispute between states being submitted to that body, and then that coming to a resolution, and that resolution being adopted by the states? Do you want to give the date and accords and the arbitration?
You answer it if you're aware of it.
Astghik, do you want to take it? Okay. Well, one question, one potential example would be the Dayton Accords to settle the Bosnian War in the 90s. There was one particularly divisive part of the territory that neither side could really agree to willingly cede, but what they did agree was to submit it to arbitration and to an international arbitration tribunal. And effectively what the tribunals it did was impose an international administration for that region. So it was neither entirely on one side nor the other side. And by and large, knock on wood, that's held through to today. We have some tensions rising again in Bosnia, but that could be one example.
I mean, states bring cases, well, just as a general premise to your question, like states control the degree to which they're exposed to the jurisdiction of an international tribunal. Kosovo was an advisory opinion, which is when the General Assembly decides that it wants the ICJ to settle on something. So it was not like Serbia even like accepted the ICJ's jurisdiction in that. It was kind of imposed on Serbia. There was, but states do dispute all the time over whether a maritime sovereignty, because there's a whole treaty regulating that, the United Nations Convention on the Law of the Sea. And so there have been a lot of cases where they fight over rocks in the ocean, or if it's in the ocean or under the ocean, that's the big dispute in those cases. But there's one about Crimea, actually. The United Nations Convention on the Law of the Sea says that whoever is the coastal state territory enjoys all these rights in the waters next to that territory. Ukraine filed an arbitration saying we are the coastal state over Crimea, and Russia is now exploring in those waters and depriving us of our rights as a coastal state. But the tribunal declined that one jurisdiction because it said our jurisdiction over under the Law of the Sea Convention is purely on the status of maritime waters. Here, you've taken what is really a land dispute that completely predetermines the status of the maritime stuff. So, yeah, I don't know if like a state, if it's like if it's really like compelled to do so, will willingly overlook something and leave itself open to have to adjudicate the status of its own disputed territory before an international tribunal. But it's the job of skillful lawyers to find these jurisdictional hooks to get that case.
We have one last question. I'm going to give preference to the chat question because we have our panelists, or at least one panelist here with us, able to discuss afterwards. So under the individual complaints mechanism, what is the scope of remedies available? Astghik, do you want to handle that?
Sure. Yeah, that's a good question. It can vary. There's a lot of different remedies that the treaty body can recommend if it does find a violation. It can be, for example, if you think about the right to housing or the right to property, it can be a recommendation that the state restore that person's property or provide alternate adequate housing. If that's not possible, there's also the possibility that the state will be required to provide some other kind of compensation, probably monetary compensation. So there is a range of recommendations that the treaty body can make if there is a violation. And the monitoring is really sort of monitoring the compliance with those recommendations rather than necessarily monitoring the situation sort of indefinitely. And as I mentioned, there are states which have adopted either legislation or whose courts have decided that the treaty body's recommendations are binding to some degree. So Spain's Supreme Court, for example, decided that the Committee on the Elimination of Discrimination Against Women's, that committee's decisions are binding. And so the state, if it's ordered to provide monetary compensation, must do so. Or Colombia, for example, has legislation which requires the state to pay whatever compensation is ordered from the Human Rights Committee specifically. And so that's sort of it's pretty broad, the range of remedies.
Thank you. I think that's time on this program. Thank you so much, panelists. Astghik, Alex, phenomenal job.
I'm just going to set this up because we're transitioning to our next panel. If you need to go out real quick and come back in, this would be a good time to do that. Thank you very much. Asthik's gone already, but Astghik and Alex and Levon, excellent presentation. The two, oh, there she is. The two reports that Astghik referenced during the presentation are ones that she participated in drafting. The Bar Association over the course of the last 12 months or so has drafted 7 different similar reports to various different UN bodies. We'll hear about that a little bit later.